just the change in the public dialogue. I would challenge you to find somebody who doesn't know what redistricting is today.
And I believe they have forfeited their seats in the state legislature because they're not doing the job they were elected to do.
The nation turned to the Texas legislature this summer as a Democratic quorum break derailed the first attempt to pass controversial new congressional maps. Governor Abbott muscled through the new maps in the second special session, but it launched a nationwide struggle reaching to California and now even Missouri. Republicans promised punishment for the quorum breaking. Democrats back at home. They changed the House rules and passed a new law.
The fallout doesn't stop there. Governor Abbott and Attorney General Ken Paxton continue to try to remove Democrats from office. In petitions with the Supreme Court of Texas, they aim for the chair of the Democratic Party and others who broke quorum.
But will any of this hold up in court? We speak to lawyer and historian Dr. Bill Criss.
He wrote a book on the 6 constitutions of the state of Texas and has been keeping a close eye on this struggle.
And they passed a law that if somebody breaks quorum, they cannot fundraise more than their per diem, which is roughly $220 a day. And then it also bans them from spending political money on housing, travel, food, for quorum breaking. Do you think that's going to hold up? Is that allowed under the Texas Constitution?
You know, that's an open question. There's no guiding authority that we have that will tell us the answer to that question. I can tell you the two sides of the coin. The first side of the coin is the Texas Constitution makes it very clear that the legislature has the constitutional authority and power to regulate its own members. So the Constitution says that the legislature, each house of the legislature, has the right to discipline its members, to expel its members, to regulate the conduct of its members, to discipline its members. So the Constitution, in addition, has a separation of powers provision, which we don't have in the federal Constitution, that makes it even more likely that deference will be shown by the courts to whatever the legislature decides to do about its own discipline. The other side of the coin is that under Citizens United, the United States Supreme Court decision that essentially equated money with speech under the First Amendment, there may be a challenge to this law, which I think is House Bill 18. There may be a challenge to this law based on Citizens United, because not so much the idea of not being able to raise funds, but particularly the restrictions on what they can be used for.
And just to double click on that, because the Texas House also passed some rules that said every day you're gone on a quorum break, you lose 2 years of seniority, and your loss of a chair or vice chair position, also a fine of 3 times their per diem, so it will be roughly 660 days. That you feel like has more legal standing because it's like internal House rules, but this state law that may question some of the political expenditures, that may be more vulnerable to a court challenge. Am I understanding that correctly?
The internal rules of each house are probably going to be given more deference by federal courts and state courts because of the separation of powers doctrine at the federal level and the separation of powers express provision in the Texas Constitution. But even those House rules, if they go too far, could transgress constitutional boundaries.
Yeah, and when they broke quorum, there were efforts and talk about removing them from office and all of that kind of business. Is that legal? How strong is the ability for lawmakers to use quorum breaks as a political tactic?
I think that it's a time-honored method of legislators expressing their will in extreme situations. The first instance of it that I know of is 1870, when the legislature did essentially that. Some members of the legislature did essentially the same thing. The business about removing the legislators from office because they refuse to appear is something that I think is based on a very weak legal argument. You would have to, the Supreme Court of Texas would have to overrule existing precedent, guiding precedent. that goes back to the 1920s on the subject of implied resignation. Because the argument here is that when these guys and gals leave, they're essentially abandoning their office, right? In order to demonstrate or prove that a legislator has abandoned her office, you have to demonstrate that they left the legislature with the intention of never coming back and of giving up their office. So it's kind of a situation where you have to prove they are resigning without actually saying so. And that's going to be very hard to prove under circumstances where the quorum busting legislators expressly disclaim that that's what they're doing. No, I'm not resigning. I'm doing what my constituents elected me to do.